Welcome to While We Were Distracted, the podcast where we explore topics that often get overshadowed in the rush of daily life. Please take a moment to like and subscribe, it really helps.
Today, May 15th, 2025, we've got two really significant legal developments hitting the news.
That's right.
First up, there's a federal appeals court ruling, Eighth Circuit, impacting the Voting Rights Act in North Dakota. And at the same time, the Supreme Court has been hearing arguments about birthright citizenship.
Yeah, two major cases, seemingly separate maybe.
Exactly. But when you look closer, they both touch on some pretty fundamental things about, democracy and rights in the U.S.
Absolutely. And we've got some good sources to dig into. NPR covered that Eighth Circuit decision really well.
Okay.
And CNN's been providing live updates from the Supreme Court hearing on the Trump Birthright Citizenship order.
So our plan today is basically to unpack these, right? Get into the core issues, the arguments, what's really at stake.
Exactly. We want to help you get up to speed quickly, cut through some of the legal jargon, and maybe connect some dots you hadn't seen before.
Sounds good. Let's start with that Eighth Circuit ruling and the Voting Rights Act. You mentioned the NPR report.
Yeah. So the big headline is that this federal appeals court, the Eighth Circuit, they've made it harder to enforce a really key part of the Voting Rights Act.
Okay, which part are we talking about?
We're talking about Section 2. Its whole purpose is to prevent racial discrimination in voting.
Right, a cornerstone.
Definitely. And this ruling affects 7 states: Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota.
So how is Section 2 usually enforced before this?
Well, historically, the vast majority of lawsuits under Section 2 were brought by private individuals or, civil rights groups.
Okay.
They typically used another law, Section 1983. It's an old law, post-Civil War, that lets people sue state officials over civil rights violations.
So private groups were doing most of the heavy lifting in court. What did the Eighth Circuit say about that?
So this was a 2-to-1 decision. The majority found that Section 2 of the Voting Rights Act doesn't explicitly say that private individuals have the right to sue under it. Their logic was, since the law doesn't spell out that private right of action, you can't use Section 1983 as the doorway to bring that kind of lawsuit.
So no specific permission slip in the text of Section 2 itself.
That's essentially the argument, yeah. Judge Grinder wrote the opinion basically saying you need that clear statement within Section 2 to use 1983.
That feels like a pretty significant shift from how things have operated for a long time. Was it a unanimous decision?
Oh, not at all.
Yeah.
There was a very strong dissent from the Chief Judge, Stephen Colleton.
What did he argue?
He really hammered on the history. Pointed out that since 1982, courts have decided over 400 cases brought by private plaintiffs under Section 2.
Wow, 400 cases.
Yeah, he basically said the majority's logic implies all those cases, for decades, should have just been thrown out. He found that pretty hard to swallow.
So what's the practical result then in those 7 states? If private groups find it harder to sue?
Well, it puts up a big hurdle. It likely shifts the main enforcement burden onto the U.S. Department of Justice. But, the NPR report mentioned that the current DOJ has apparently stepped back a bit from some Section 2 enforcement.
So potentially fewer challenges overall.
That's the concern, yeah. Fewer lawsuits challenging practices that might be discriminatory.
And this all came out of a specific fight in North Dakota.
It did. The case started with a challenge to North Dakota's state legislative map after the 2020 census.
Who brought that challenge?
The Turtle Mountain Band of Chippewa Indians and the Spirit Lake Tribe. They argued the new map diluted Native American voting strength.
How so?
They said it reduced the opportunity for Native voters to elect candidates they prefer, especially in areas where voting is racially polarized. And they pointed to a stark fact.
Which was?
For the first time in over 30 years, there are 0 Native Americans in the North Dakota State Senate right now.
Wow. That really brings it home. What was the state's position? North Dakota's argument.
Well, the state's Republican Secretary of State basically argued what the court's majority eventually agreed with, that Section 1983 just isn't the right tool for private Section 2 lawsuits, that the legal basis wasn't there despite the history.
And the tribes and their lawyers, how did they react to the ruling?
Disappointed, as you'd expect. Groups like the Campaign Legal Center, the Native American Rights Fund, they represent the tribes. They strongly disagreed, said they'll keep fighting.
Did they say what that fight might look like?
They're weighing options, possibly an appeal to the Supreme Court. One lawyer warned this, quote, hobble the most important anti-discrimination voting law.
And is this argument that private individuals can't sue under parts of the Voting Rights Act, is it popping up elsewhere?
Yes, that's a key piece of context.
Mhm.
The NPR report notes that officials in Arkansas and Louisiana have made similar arguments recently.
Really?
Yeah, apparently spurred by a statement from Justice Gorsuch. They're questioning private lawsuits under Section 2 and also Section 208, which deals with voter assistance.
So this could be heading towards a larger showdown, maybe at the Supreme Court.
A lot of observers think so, especially given some other recent Supreme Court decisions that have, let's say, narrowed voting rights protections.
Okay, a really important development to watch. Let's shift gears now to the other big story. The Supreme Court and Birthright Citizenship. We're using the CNN live updates for this.
That's right. So the justices heard oral arguments today about President Trump's executive order on birthright citizenship.
But, and this seems crucial, they weren't actually deciding if the order itself is legal or constitutional.
Exactly. That's the key thing to grasp up front. The question before the court wasn't about the substance of the order. It was procedural.
Procedural in what way?
It was about whether the lower courts went too far when they issued nationwide injunctions.
Okay, explain that. What's a nationwide injunction in this context?
It's when a single federal judge issues an order blocking the government from enforcing a policy anywhere in the country, not just for the specific people suing in that one case.
Got it. And remind us, what is birthright citizenship and what did Trump's order try to do?
Sure. So the 14th Amendment says all persons born or naturalized in the United States are citizens. For, well, over a century, that's been understood to mean if you're born on U.S. soil, you're a citizen. Period.
Yeah.
Pretty much regardless of your parents' status.
The Wong art case established that, right?
Right, back in 1898.
Uh-huh.
Now, Trump's order, issued when he returned to office, aimed to change that. It told the government not to recognize citizenship for babies born here if their parents were in the U.S. unlawfully, or even just temporarily, like on a visa.
And the lower courts pushed back hard on that.
They did. Multiple federal judges blocked the order pretty quickly. They basically said it looked clearly unconstitutional, flying in the face of the 14th Amendment and that Wong precedent.
So, back to the Supreme Court today. What was the administration's argument against those nationwide injunctions?
The Solicitor General, D. John Sauer, argued for the administration. His point was that lower courts just don't have the authority to issue these sweeping nationwide orders. He argued their power is limited to the specific parties in the case before them.
How did the justices react to that argument? Did anyone push back?
Oh, yeah. Justice Kagan seemed particularly skeptical. She kept pressing Sauer on the practicalities.
Like what?
She asked him, okay, let's just assume the order's illegal. If you can't have a nationwide injunction, what happens? Does it get enforced in some places but not others? How long does it take to sort that out?
Did he have a clear answer?
According to the reports, not really. She seemed frustrated by the lack of a clear path forward in that hypothetical.
What about other justices? Sotomayor?
Justice Sotomayor also raised serious concerns. She worried that limiting nationwide injunctions could even tie the Supreme Court's own hands later, making it harder to ensure its rulings apply everywhere.
Interesting point.
Yeah. And she was blunt about the order itself, saying it, quote, violates 4 Supreme Court precedents. She even posed a hypothetical. What if a president ordered the military to take everyone's guns? Would courts just have to wait for individual lawsuits?
Powerful hypothetical. Did the Chief Justice weigh in?
Chief Justice Roberts did. He brought up redistricting cases. Those cases inherently affect a whole state map. He questioned how you could fix an illegal map without a broad statewide injunction.
How did Sauer respond to that?
He tried to argue redistricting is different, requiring a geographic solution, but Roberts didn't really follow up extensively, left the question hanging a bit.
Any other notable lines of questioning? Justice Thomas?
Justice Thomas characteristically focused on history. He wanted to know about the historical analogs for these kinds of universal injunctions. Questioned whether examples provided were really comparable.
While all this legal debate was happening inside, President Trump was active on social media.
He was. Posted on Truth Social, reiterating his position, said he wants to end birthright citizenship, questioned if it was meant for people having kids while on vacations here. And he repeated that argument that the 14th Amendment citizenship clause was only intended for the children of former slaves.
Which, as we discussed, contradicts the amendment's text and the Wong arc ruling.
Flatly contradicts it, yes. The Wong arc case involved a child born in the U.S. to Chinese parents who were legally resident but couldn't become citizens then. The court said he was a citizen by birthright. It wasn't limited to any specific group beyond being born here and subject to U.S. law.
Did the reports mention Justices Kavanaugh or Barrett? Sometimes they're seen as potential swing votes or looking for middle ground.
Yes. CNN noted they've both previously expressed some, let's say, nuance on nationwide injunctions. They seem aware of the potential problems, but also worried about disuniformity, like what happens if different courts rule differently on the same federal law.
So they might be looking for a way to thread the needle.
Possibly. They seem concerned about the chaos if a law means one thing in Texas and another in California, for example.
It's also worth noting no TV cameras in the court. Right, just audio.
Correct. Audio stream was available, but no video.
And one final point from the CNN coverage, this issue of nationwide injunctions, it cuts both ways, right? It's not just Trump policies that have been blocked this way.
Absolutely crucial point. The report highlighted that the Supreme Court itself has upheld nationwide injunctions blocking some of President Biden's policies, too.
So the frustration with these injunctions isn't exclusive to one party.
Not at all. It's a broader debate about judicial power and executive action, affecting presidents of both parties.
Okay, so we've looked at these two big stories, the Voting Rights Act ruling in the Eighth Circuit, the Birthright Citizenship arguments at SCOTUS. When you pull back, what's the common thread? How do they connect?
Well, I think the clearest connection is that both cases wrestle with really fundamental questions about individual rights versus government power, and also about the role of the courts in defining and protecting those rights. You know, how much power do courts have to step in?
And both involve interpreting some long-standing laws or precedents.
Definitely. The Voting Rights Act case is about how you read Section 2 and its enforcement mechanisms after decades of practice. The citizenship case hinges on the 14th Amendment and that century-old Wong arc precedent. Both could really shift the ground under people's feet regarding voting and citizenship.
So just to recap quickly, the Eighth Circuit ruling makes it much harder for private individuals and groups to sue over alleged racial discrimination in voting in 7 states, potentially shifting enforcement to the DOJ.
Right.
And the Supreme Court heard arguments not on whether Trump's birthright citizenship order is legal, but on whether lower courts can issue nationwide orders blocking such policies.
Exactly. The focus was on the scope of judicial power, the remedy, not the underlying right in this specific instance.
Okay, lots to think about. Here's a final thought for you, our listeners. When you see these kinds of challenges and reinterpretations of laws like the Voting Rights Act and the 14th Amendment, how do you think the balance of power might be shifting? You know, between individuals, the states, the federal government, and the courts.
Yeah, and maybe relatedly, what does it mean for the predictability, the stability of our legal system when these foundational principles face such direct challenges?
Definitely questions worth pondering.
Indeed.
Well, thank you for joining us for this deep dive today. We hope this helps you follow these important legal stories as they continue to develop.
Please take a moment to like and subscribe. It really helps.